All right, we're going to kick this thing off. This is going to be an action-packed hour and 15 minutes for which you all will receive CLE credit. So there are going to be some keywords interspersed. Pay attention so you can get your credit and not have to do CLE again. I am so delighted to be here with this all-star panel talking about Watergate, Whitewater, and Beyond, like today, an inside look at presidential investigations. We have Earl Silbert from DLA Piper, who Chambers calls one of the most revered lawyers in Washington, but of course, we already knew that. Thank you, Earl. We have John Sale, who's co-chair of the White Collar and Government Investigations Group at Nelson Mullins, and who is happy and in great color because he lives in Florida, not Washington. And of course, we have Saul Wisenberg, who no longer lives in Washington either, but seems to be on NPR and television all the time, for which I am very grateful, talking about Whitewater and all sorts of criminal law issues and his friend Brett Kavanaugh and a whole bunch of other things. So we're going to be talking for about 45 minutes, and then after that, we're going to have about half an hour of your questions, so think of them. We'll all be eager to field them. We're going to start out by talking about Watergate. There are a lot of issues related to Watergate that are still relevant and resonant in this day. And I wanted to start out with Earl Silbert, who pointed out to me in the green room that he was investigating these matters not for the Justice Department, but within the U.S. Attorney's Office in Washington, and investigating them very actively before anybody like Archie Cox or Leon Jaworski was ever appointed a special prosecutor in this case. Earl, can you describe what was going on behind the scenes when you were that first assistant U.S. attorney? All of that activity happening behind the scenes before any special prosecutor ever came on the scene.
The U.S. Attorney's Office was given the responsibility for handling the grand jury investigation right after the arrest of the 5 burglars in the complex, the Watergate offices of the Democratic National Committee. And to us, it was, I had 2 assistants working with me, so there were 3 of us that were handling this case. And it was, in some respects, an ordinary case like others that we handled. And of course, in other respects, there were so many extraneous issues and issues that came up that were not normally handled or confronted with, that it made the representation a very exciting one and very memorable. But the line of authority was Kleindienst. Mr. Kleindienst was Attorney General. He supervised Henry Peterson, who was the Assistant Attorney General in charge of the Criminal Division. And these were kind of household names at the time. And I reported to Henry Peterson about 3 or 4 times a week to bring him up to date as to what was happening, what we were planning on doing, and the like. And of course, as the boss, he could say yay or nay, but most of the time he said yay. But that investigation was a field investigation of the U.S. Attorney's Office in D.C., and that's the way it went forward all the way up until Professor Cox was sworn in as the special counsel and took over the investigation.
Earl, at what point did you learn that your boss, Henry Peterson, to whom you'd been reporting about this investigation sometimes 3 or 4 times a week, may have been sharing that information with the President of the United States, Richard Nixon, and people in the White House?
It was during that April, May period that, and I can't, 40 years later, some of these things fade just a wee bit, but I can't remember the exact setting or context in which I learned that. In fact, it may have even come from the press, and we had a discussion. That is, Mr. Peterson and I had a discussion about that because I had certain views as to the wisdom of doing that, and Peterson was dealing with the President of the United States. He was the one that had the direct contact. I did not. And he was very impressed by the Attorney General and all by the president and the two of them, and he was reluctant to take a stand that of the kind that I was advocating on this occasion.
So he was your boss and he just kept on doing what he was going to do.
Well, at one time it was disturbing enough that I just kind of stopped sending the transcripts over to the department and just waited to hear what might happen, and nothing really did happen. So,
And, it later came out that when the tapes came out, that when Peterson was relaying some grand jury information to the president, and there's a legitimate question, however wise it is or not, there's a legitimate question whether or not the president as chief law enforcement officer has a right to listen to 6E material.
Even when he's the subject or target of the federal criminal
Yeah, it's obviously completely sleazy and improper. But the question is it constitutional? And which is often a question that comes up today. And but at one point in the tapes, President Nixon says to Henry, I know I'm not supposed to tell anybody about what happens in the grand jury. And then 5 minutes later, he's telling Haldeman and Ehrlichman. So unbeknownst to Henry Peterson. So.
If I can weigh in?
Please.
After Watergate, there were protocols established, but hindsight is always 20/20. And I have to say that protocol or no, for somebody to say to the President of the United States who inquires, it's none of your business, takes a lot of chutzpah. It's very, very difficult to be able to do something like that. But I started my prosecutor's career in the Southern District of New York. And
Sovereign
when I
District?
was still there, did you say Sovereign District? Yeah. All right, well, this illustrates. When I was still there, there was an indictment returned charging John Mitchell and Maurice Stans. And the United States Attorney, my boss, took the shuttle from New York to Washington, D.C. to meet with the Attorney General, and as a courtesy to tell him, oh, by the way, for the last 6 months, we've been conducting this investigation, and as we speak, Mitchell and Stans are being indicted. So in the Southern District, the President, even the Attorney General, were not informed what we were doing. For better or for worse, that's just an anecdote from history.
All right. For those CLE people, your word is stonewall. Remember it. I'm going to give it to you one more time. Apropos of nothing. Earl and John, there's a debate now about whether the Justice Department can just handle these investigations itself. Why you need to bring somebody in from the outside to do this anyway? What do you think?
well, that's a question that can merit an answer that would take a long period of time. It was controversial. The question was frequently made during the investigation into Watergate that the U.S. Attorney's Office couldn't conduct the investigation in a fair and vigorous, even-handed way. And I think history has countered that allegation, although at the time it was one that was articulated. There'd be trade-offs. My view, for whatever my view counts, as one who was involved in the case in which the department handled the investigation. The department came across or discovered the mammoth conspiracy to obstruct justice that eventually led to the resignation of the president. But there were others that felt that how in the world could an assistant U.S. attorney who's working for a Republican U.S. attorney, who's working for a Republican assistant attorney general in charge of the criminal division, who's working for an attorney general who's a Republican, under all those circumstances, how could that assistant U.S. attorney be even-handed, impartial, and the like? And that issue was floated and led to the enactment, ultimately, of a statute, independent counsel statute. Initially, there was an effort by the Congress to work through just internal independent counsel, like Professor Cox was appointed to take over the Watergate prosecution, and that was the initial response. But that lasted for Professor Cox, and then the next thing that happened was there was a independent counsel statute in which for certain crimes, and everything was laid out in the statute, whether or not the prosecution, the standards, the tests, and the like, that had to go through the independent counsel and could not be handled or directed by the Department of Justice. And that existed for about 10 years, and by that time I had left the U.S. Attorney's Office. I was in private practice. That statute didn't work, at least certainly from my perspective, and I know from many of the members in the D.C. bar. It didn't work for one reason. Power corrupts. All power corrupts, absolutely. And under the independent counsel statute, the prosecutors were, almost 100% as a practical matter, independent. And there were a number of those prosecutors, independent counsel, my view, who couldn't handle it. They couldn't handle the power. It just led them to make mistakes and errors of the kind that should not occur. And eventually, that statute expired by its own terms and has since not been reenacted. Now, whether or not, Carrie, there'll be efforts to come back and say we have to be independent, prosecutors have to be independent. They can't do it if they're in the Department of Justice. I don't know. I come out on the side that, yes, I recognize that argument, but that is the argument that independent counsel are needed to assure an independent prosecution. That the Department of Justice attorneys, many of them career types, are certainly going to be reliable enough and do right in conducting their investigations and prosecutions.
Earl is a consummate gentleman. So he's not addressing the following. If I were in his shoes and I were, to be very blunt about it, being replaced, I wouldn't be very happy about it. Just like in the private sector, if you're representing a client and if all of a sudden you're notified you're being replaced, you may be very polite on the outside, but nobody really likes it. But history has shown two things. First, that Earl and his team, nobody could have done a better job than they were doing. And the replacement was more institutional, and it was appearance-wise. And I want to make it clear, because I think we're going to talk about a number of things about Watergate, because I was in the Watergate Special Prosecutor's Office. I was not a member of the senior staff by any means, but the office was small, and a lot of the things I'm probably going to talk about in the course of this panel are things that I either know firsthand or members of the senior staff shared with me, either at the time or later on. And one of our senior lawyers, was a guy named Jim Neal, who was, if I were to list 3 or 4 lawyers in my entire career who I thought were the best trial lawyers I've ever seen, Jim would be right up on that list with Edward Bennett Williams. And Jim was the transition person who was sort of transitioning, as I understood it, between Earl and us. And Jim, who I really got to know better in private practice after Watergate was over, told me that Earl and his team did everything right and couldn't have been easier to work with in the transition. But I remember asking Jim, who had been the U.S. Attorney in Nashville, Tennessee, and had participated in the Jimmy Hoffa prosecutions under Attorney General Bobby Kennedy. And I remember being in his office in Nashville and asking him, you had just left the government, you just started a law practice. Why did you come down, albeit in the beginning part-time? Why did you want to come to Washington and disrupt your life? And he pointed to a picture on the wall. I'll never forget this. And I had to look closely to see who was on it. And it was Attorney General Kennedy with his sleeves rolled up at the big conference table. And he said, you see some of the people around him? And he pointed out Nicholas Katzenbach, Ramsey Clark, Archibald Cox, who became the special prosecutor. And he said, you see him, that guy? And I looked, and he said, that's me, Jim Neal. And he said, it was a piece of history. When Archie called, he's an old friend, he showed him the picture, I couldn't turn him down. But that is how Jim Neal got involved, how he transitioned. And Jim Neal, in the big Watergate cover-up case, he was the lead prosecutor. So I wanted to just extend that compliment to Earl, which is justified by history.
I want to bring in something we hear once a week, once a month, from people on Capitol Hill and sometimes people in my business. We are living through a slow motion Saturday night massacre. The FBI director, Jim Comey, has been fired. The deputy FBI director has been fired. Various other people have been fired. Some Democrats on Capitol Hill in particular are asserting we are right now living through a slow motion Saturday night massacre. John Sale, you actually lived through the legit Saturday night massacre. What was that like? And are we having one now?
Actually, the characterization of slow motion Saturday Night Massacre, I've heard several. This discussion is not partisan at all, but I've seen several Democrats call it that, and I don't know. Because slow motion, we haven't gotten to the end, so I'm not sure whether or not it even applies. But the Saturday Night Massacre, I don't think there's anything in my professional life that I will ever remember the way I remember the Saturday Night Massacre. It started when John Dean gave this testimony against the president, where John Dean said the president was in the middle of the cover-up. He talked to him about it. He talked to him about a cancer on the presidency. And I remember I had not yet come down to the office yet, but I heard that on television. The Irvin Committee, people were riveted to their TVs. I mean, that's really the word. It was the first time there was ever anything like that. And it was on in the daytime, and it was on everywhere. But it was uncorroborated. I was a lawyer. I had been a prosecutor, and John Dean is saying that, but how are they going to really demonstrate that beyond the word of John Dean? And then fast forward to Alexander Butterfield saying there are tapes. Not the kind of selective taping like many presidents have done, but tapes of virtually every conversation with the president in both of his offices and even on the telephone. So there was the ability to corroborate John Dean or exculpate the president. And I can't speak for every one of my colleagues, but I know most of them felt if the president was exculpated, cleared, we weren't going to be upset. Our job was to uncover what happened, was not to get the president. And I think that's why we did it right. But so the Saturday Night Massacre, fast forward. The existence of tapes, which, by the way, let me just say, Jim Neal, since I mentioned him, he thought, his first reaction was it was a ploy. He thought that, wait a minute, this can't be. There is no way that every conversation was being taped. It's a setup. So what they're going to do is they're going to give us a bunch of tapes. They're going to be innocuous. Then they're going to say, you see, there's nothing to what Dean said. Executive privilege as to the rest of them, go home. But Jim agreed eventually that if there are tapes, we need to try and get them. So it started out with a voluntary request. The president had retained Charles Allen Wright, who was a great constitutional scholar, a law professor, University of Texas. The voluntary request said, no, we're not going to turn them over. But what we did was, and when I say the we, I'm not taking credit in any way, I'm just suggesting we collectively, the office, was so not to be accused of going on a fishing expedition, we asked for only nine conversations around the events that Dean described. So the answer is no. Then comes a subpoena. It's litigated before Judge John Sirica, whose name you'll hear a number of times, I think, in this discussion. He rules in our favor. The White House asserted executive privilege. Judge Sirica said, well, it's a balancing test. Turn those tapes over to me, the court, and I'll do an in-camera review. The White House appeals. The Court of Appeals affirmed.
You guys appealed too. You crossed the.
Of course. There was an appeal. The Court of Appeals affirmed Judge Sirica, but actually did not require even an in-camera review, that they should be turned over to us. But the language in the Court of Appeals decision, there's a lot of language, no one, including the president, is above the law. Now, they now have this was on Friday, October 12th. And the only reason I remember that date, I don't memorize dates, but it had significance. They had 1 week until Friday, October 19th, if they were going to go to the Supreme Court. During the course of that week, there were discussions between the senior staff in my office and people in the White House. And the people who represented my office would come back, and in the beginning, they were talking about various ways of working it out. And towards the middle or the end of the week, they were saying the discussions were more threatening than negotiating. I was sent to handle a plea in St. Paul, Minnesota. And when I asked Henry Ruth, who was the deputy, I said, when can I see you and Archie Cox to give you a debriefing of what happened in Minnesota? Hank Ruth said to me, you can see us anytime you want, assuming we all still have jobs. And all of a sudden, because as I wasn't in these meetings, I was one of the young lawyers, but when I heard him say that, I said, Hank, you're kidding? And he said, oh, I'm not kidding. He said, but we'll talk about it some other time. So I got the message that this was serious. But anyway, there is a quick story. So Thursday, Archie Cox leaves and he goes for dinner to his brother's house. And his brother has young children. And there's a phone call. And the phone call, one of the kids says, Uncle Archie, it's the White House. And everybody was really impressed. Says, wow, the White House is calling. So Professor Cox takes the call, and it's Charles Allen Wright. And for the first time, he spells out what I'm going to tell you about in a minute, which came to be called the Stennis Compromise. And Archie Cox said, Charlie, this really isn't the best time. I'm sitting here in the den with children. We have games out. He says, is this something we could talk first thing in the morning, talk about? And of course, Professor Wright said, sure. But it turned out that the Stennis Compromise was the following. We're not giving you tapes, but we are going to have Senator John Stennis prepare transcripts and authenticate them to tell you that this is really what's on the tapes.
There's
And
something about Senator
Senator Stennis, who not only was he in his 70s, but...
Wait a minute.
No, I'm going to say, hold on. Listen.
Oh!
And when you get to be 70, you may have standing to object. But about 6 months before, he had been the victim of a crime. He was mugged and shot, and he was quite seriously wounded.
And he couldn't hear either, could he?
Oh, and he had a hearing problem. So imagine, although this wasn't the real point, imagine Senator Stennis goes sitting in the archives with earphones and a quill pen or whatever and preparing transcripts. I mean, it just couldn't happen. I mean,
And this was the great compromise that the lawyer for the White House was floating to y'all.
But don't think that because it was done in the White House, that it was like going to the Philharmonic Orchestra and it was very hard to hear. So it was not realistic. But the most important part of the so-called Stennis Compromise was, and because you're getting these transcripts, you may not seek any additional evidence in any way from the White House. So it was a way of setting up our office to say, no, we can't do this, and then you're being insubordinate, and then you could be fired, and the whole thing can go away. So maybe is this another slow motion Saturday Night Massacre? So Friday, the deadline to go to the Supreme Court comes and goes. The White House doesn't file anything. Elliot Richardson, the Attorney General, gets a call from Al Haig, who is the Chief of Staff at the White House, Friday night. And General Haig says, direct Cox to accept this proposal. Richardson is furious. He calls Cox and he says, I'm going to read you this letter, but it's for information purposes only. I'm not directing you to do it. I'm just telling you this is what the White House is doing. Saturday, Professor Cox had, and I encourage everybody to look at this on the internet, an incredible press conference where those of us who went at the National Press Club, you got goosebumps. This was Archie Cox and his most glorious, in which he says it would be a breach of trust to the American people for me to accept this type of instruction. And then in the typical professorial way, he talked about Andrew Jackson, and he said, I know eventually they're going to get somebody to do it. And he said Andrew Jackson fired a Secretary of the Treasury, then he fired another one, and then he fired another one as a bank, taking money out of the bank, the bank. And he finally got someone to do it, and he said, but it's not something I can do. Elliot Richardson, at the same time, is summoned to the White House. And this has been written about. And Elliot Richardson meets with the president one-on-one. And Attorney General Richardson says that he was, in essence, offered a bribe. The president was dangling before him, look, if you do this, Elliot, you've always wanted to be ambassador to England. That's easy. And he even dangled the possibility of helping him get on the ticket in 1976. And then the president said, I'm sorry that you are putting your own personal agenda, I'm paraphrasing, ahead of the national interest. And you can look on the internet and you'll see Elliot Richardson saying, and my blood boiled. And I said to the president, Mr. President, I'm sorry that you and I don't see eye to eye that what's in the national interest. So he said, I can't do it. So Saturday night, we all knew something was coming. On Friday, a bunch of people in my office, I think the statute of limitations is run if this violates any law, but opened up safety deposit boxes. I know that I was involved in a sensitive investigation where all I took was my handwritten notes. And I took them out of the office. We had a very important witness that I was working on who was about to cooperate. And I actually rented a conference room at the Statler Hilton Hotel rather than schedule the meeting in our office for Monday. But anyway, Saturday night, a few of my friends were at my house because we just didn't know what was going to happen because we were at Professor Cox's press conference. And the most popular television show there was at that time was called All in the Family, for those of you who are young and don't remember it. And I'll never forget that there was an interruption and bulletin, and the bulletin was, the Attorney General of the United States has resigned. The Deputy Attorney General has been fired. The special counsel, the special prosecutor has been fired. The entire staff of the special prosecutor's office has been fired. And I've always wondered since then, on a job application, when you ask, have you ever been fired, or asked to resign from a position, how I answer that. But so we all rushed to the office, and it was chaos, it was confusion, and we learned the FBI was occupying, if that's the right word for it, our office. And we were told that the FBI was sent to also occupy the office of the Attorney General of the United States and the Deputy Attorney General. Some of my colleagues went in, and there are stories that are legion to see what's going on. Why are we being occupied by armed law enforcement? Hank Ruth, my boss, said, welcome to Moscow. He also
But
said...
were these, to be clear, were these occupiers on your side or on the side of the President?
What made matters worse was, and this was not done intentionally, but when the FBI was ordered to occupy our office, as a matter of just the bureaucracy, the agents were the very agents that were working with us and were our colleagues. And they were very apologetic. And they were saying, we don't really know how to handle this. And the most classic story, which is in this book that Saul is leafing through, a book called Not Above the Law by Jim Doyle, who was our press spokesman, is
Great
Jim
book.
Doyle. Jim Doyle, and I was there. We were all in the waiting room, so it's true. Jim Doyle had a few things under his arm, and one of the agents who worked with us said, Jim, I'm sorry, you're not allowed to take anything out. And Jim Doyle said, his name was Angie Lano, the FBI agent. He says, look, Angie, it's the Declaration of Independence. Just stamp it void, and I'll take it home. We also had security guards who were Department of Justice employees, and they were armed. And when the FBI came in, the head, I can picture him now, the head security guard who had been with us for months, said to the FBI, you're going to have to shoot me if you want to take away our weapons. We're not leaving. So nobody was there with any joy, with any glee. So we didn't know what was going to happen. I don't mean to make light of this. I mean, this was really pretty scary times.
And let me interrupt for a second and just ask you, my recollection is not only did they fire Cox and say that you were all going to be fired, but initially, before the Great Reaction, they said that basically the office is closed, the entire office is closed, the investigation is shut down.
Well, that was unclear. Some reports were we being absorbed into the Justice Department, and it was unclear. Our new boss was, it's another whole story, was Robert Bork, who had been the Solicitor General, who has really taken a bad rap in history because Elliot Richardson has further written that Bork was considering carrying out the president's order because and firing Cox because he believed the president had the authority, but then resigning. And Richardson persuaded him to stay on because he said, when is it going to stop? For the sake of the department, if you resign, then maybe the next one will resign, and the institution has to go on. But what happened, Monday was a holiday, and what happened in those 2 or 3 days was absolutely extraordinary because it was the public reaction. And that's what, if anything happens now, I don't know what the public reaction will be. But the public reaction then, we didn't have cable news, there was no 24/7 news cycle, and it was spontaneous, so it was not organized. And I have here in front of me, but I'm not going to read it or refer to it, but the public reaction was beyond the ability to describe to the Hill, to the White House. So what the president had done just was not sustainable politically. So Monday was a holiday, which was good because it gave everyone a little bit more breathing room. But this was the possibility of a real constitutional crisis because that term is being thrown around where it's not really applicable because what we were facing was the executive branch defying a court order. So Tuesday morning, Judge Sirica calls in the grand jury. And what he did was, and it's recited in Jim Doyle's book, he simply said, ladies and gentlemen, I want to read you your oath. And he read them their oath, and then he said, I'm sure you're aware of the events over the weekend. The court wants to assure you that your business will continue uninterrupted. Thank you, and come back whenever you're scheduled to return. And then he said, we're going to reconvene at 2 p.m., and he did ask for the senior members of the staff to come into his chambers, at which time, and it's in James' book, he said something, he didn't reveal what was going to happen, but he said the law, what was the quote, Saul?
The law can take care of the situation.
The law will take care of the situation.
And he thanked you guys, he thanked them for not having made any stupid public statements.
Thanked us for not making public statements. And one of the things I got to tell you that was happening internally was we all debated, should we continue? Should we stay? Do we really want to be absorbed into the Justice Department?
Some people wanted to issue a manifesto or something. Right?
There were all sorts of crazy thoughts coming from young lawyers. But then there was a consensus. Hank Ruth finally said, everyone who is going to do something off the reservation, not stay, raise their hand, and not a hand went up. But a statement was drafted, and the idea was at this hearing before Judge Sirica, which was going to be in the afternoon, that Hank Ruth or somebody would read that statement expressing our view in protest. So we come back at 2 o'clock, and let me say, Charles Allen Wright, on that Tuesday, there was no communication, except we saw him on the Today Show. And on the Today Show, he said he's very pleased that the president had issued this very fair compromise, the Stennis Compromise, and he's disappointed that Archie Cox had not accepted it. 2 p.m. comes along, and Judge Sirica had not shared with anybody what was going to happen, and we all assumed he was going to hold the president in contempt. And that would be a constitutional crisis. And Charles Allen Wright, Judge Sirica started to read the Court of Appeals opinion excerpts from it, and the order, which now was the law of the land because they did not go to the Supreme Court. And Charles Allen Wright stands up and he says, I'm not prepared to respond to Your Honor's question, but I am here to tell you that we will comply with the subpoena, and this, quote, this president does not defy the law. Everybody was ready to fall off their chair, breathe a sigh of relief, and Judge Sirica said something to the effect about how pleased he was to hear that. He said, do you mean you're actually going to produce what's called for? And Professor Wright said yes. We didn't know at the time that 2 tapes would be missing. One would have an 18-and-a-half-minute gap, but that can be dealt with in litigation. I mean, those things happen. But saying, no, court, we're not accepting your authority, that we were on the precipice, and that didn't happen. And then the rest of history is A new special prosecutor was appointed. He had now assurances of independence, and it was a matter of politics because the Republicans and the minority would not support the president in defying the law. Today, we might have another discussion, maybe we will, about where we stand now. But that's the Saturday Night Massacre in 5 to 10 minutes.
Thank you. Thank you for that. I want to direct this next question to Earl and Saul. And that's, we have a cliche from Watergate that everybody in my business seems to repeat, but they repeat it because it's true, that the cover-up, that the obstruction is usually worse than the underlying crime. And Earl and Saul, you both have a couple of examples, I think, centered on a golf course where a senior official in the Nixon administration was trying to lean on the Justice Department to kill this investigation.
Well, actually, it wasn't a senior. It was G. Gordon Liddy leaning on a senior member.
Yeah.
It was a very famous incident that I don't think Earl knew about contemporaneously. He should talk about it. Where I think the Watergate burglars were arrested like at 2 a.m. on a I can't remember whether it was a Saturday or Sunday, but whatever it
Saturday
was.
morning.
Saturday?
Saturday morning.
Yeah, but like by that afternoon, Liddy walked onto the Burning Tree golf course and interrupted Attorney General Kleindienst's game. You want to take it from there, Earl?
Sure. He went out there with, pursuant to direction, that is, Liddy went out there, and Liddy was, I don't know how much you folks know how much you don't, but originally there were 7 persons indicted for participation in the Watergate burglary and breaking in. And if you wanted to rank them in terms of authority within that group of 7, Liddy was the top person. And of course, what I'm about to give you, I didn't know this at the time, nor did our team, but Liddy went out with a media type to see the Attorney General, that is Attorney General Kleindienst, and convey to him a message that he was there at the instance of former Attorney General John Mitchell, who was also head of the Committee for Re-election of the President. And Liddy went to convey the message that I just described, and but what he said, that he was here at the instance, John Mitchell asked him to make to report and advise him of that. Then
And to call someone.
well, to call and let the head of the criminal division, Henry Peterson, know. And what Peterson was told was that Liddy had appeared, and that he had made the request, and Kleindienst says to Peterson, treat this case like any other. Now that sounds pretty good in a sense. Don't give any favorites, treat the case evenly. But what he omitted to say was that he was there at the instance of Attorney General Mitchell, former Attorney General Mitchell. And we didn't know that. Certainly the department wouldn't have known that. Mr. Peterson didn't know it, as far as I know. And that by itself, that little conveyance of the distinction between the two messages, that had in a way a profound effect, because had Peterson been told that the former Attorney General Mitchell has requested this, that would have provided a huge avenue for investigation as to, well, why should the former Attorney General have any influence or power to determine what is going to be done? And it's to prosecutors, something like that is one was very troublesome, and the question arose, and former Attorney General Kleindienst was investigated by the special prosecutor to determine whether or not he had acted properly or improperly.
I think it's also important to remember what the request was, as I've read it, conveyed through Liddy, by Mitchell through Liddy, was get these guys out of jail. Shut the investigation down. But when you talk about obstruction, I'm struck in the current situation with President Trump. There's a lot of discussion about is it a lot of debates on TV that I've been involved in as well about can it be criminal obstruction of justice simply to fire somebody like your FBI director if your motive is a corrupt one, if the motive is to protect yourself from investigation for a crime. There are people who debate that, but by and large, in the case of Nixon, you're talking about classic mob-type obstruction of justice. You're talking about people who were paid hush money. You're talking about people who were promised clemency. You're talking about people who were told to lie at the grand jury and did lie. And almost all of this stuff, by the way, coordinated by John Dean, who I saw recently referred to as a whistleblower, which is a rather expansive interpretation of that term. But I mean, you're talking about things that nobody could argue except perhaps in some instances, your friend, Mr. Giuliani, is anything other than obstruction of justice, right? Unless your position is just the president can never break the law because he's the president. And I don't think you've got that based on the public record in
There are
President Trump's
news
case.
reports that the president's former personal counsel had sought to direct legal defense fund money to two people who later pleaded guilty in the
Right, but
case.
that-
And there are news reports lots of news reports about dangling pardons in front of those individuals.
Right,
before
but so far what we have, that can be an ambiguous area. There's nothing wrong. This happens every day in this town that I don't know about every day, but where a person with means can pay for the defense of somebody else. And in D.C., when you do that, if you're the person representing the individual whose defense funds are being paid by somebody else, you put a provision in the retainer agreement that says this is happening and here are the ethical consequences of it. So what I've heard about the situation with President Trump is ambiguous. But in the case of Nixon, you've got Howard Hunt saying, where is the money you promised me to keep my mouth shut? Okay, and then he got the money. Okay, so it's much more blatant.
Saul mentioned John Dean, and it's true that he was not a good Samaritan, a whistleblower. He pled guilty to a felony, and he himself directed the payment of hush money, amongst other things, but something that's not widely known to his credit. During the week preceding the Saturday Night Massacre, literally the day before, on Friday, was the day he entered his guilty plea. And Jim Neal felt conflicted because he knew something that the defense didn't know. And when they got to the courthouse, Jim said to John Dean's lawyer, and John Dean was standing right there, so he heard it, I need to tell you something. I need to tell you that there's, I don't know, whatever's going on with the White House, and I want to tell you before you enter this plea, we may not be here on Monday. It's possible my office will not be here. Basically saying, hey, look, if you don't want to go through with this, because come Monday, you're going to say, once it's in the system, it's in the system. And John Dean himself, without looking to his lawyer, said, no, I've made this decision. I'm going to do it. So,
And can I just say one thing?
Quick, yeah.
Stonewall.
Thank you. Thank you very much, your CLE word. And I see my friend from Williams and Connolly was here listening intently to the idea that the government was giving full disclosure to the defense in the John Dean case. We got to move along and get to questions, but one last thing. The idea that President Trump and the people who work for President Trump are following a finely honed over generations playbook of attacking the government. Earl Silbert, you told me you got criticism from the left and the right. Saul Wisenberg, you have a quote about kneecaps and James Carville, who's in the news again this week.
Well, first of all, I think all three playbooks are the same. That when you start reading the history, the attacks on the prosecution staff, whether they're special counsel, independent counsel, or DOJ, are remarkably consistent. The theme is the investigation is a coup attempt. This is both in Whitewater Watergate, and now. The investigation is a coup attempt. The investigation is a fishing expedition / witch hunt. It's staffed by my enemies who are out to get me, using unfair, illegal tactics. I could go on and on. The story I tell about when I got the completely unexpected offer to come work for Ken Starr was about a week or two after James Carville had said publicly, Judge Starr is one more mistake away from not having any kneecaps, which I considered kind of thuggish. I don't know. And the difference between that situation and the current one is that the president here says that stuff himself. He doesn't send somebody out to say it. But you know, Carville was an ally, was a guest at the White House often. And so I sat down with my then wife and said, before I decide whether or not to take this position, let's talk about every bad thing I've ever done. Because if we get close to this president, I have no idea what they're looking at, but if we get close to this president, they're going after us. I know this crowd. So that's kind of my story.
You know, the attacks on the press now, fake news, enemies of the people, which are really pretty chilling and scary. But again, the same playbook that existed with President Nixon, but the quote that I looked it up to make sure I got it right, but I'll never forget when he said at a press conference, and I'm quoting, "Don't get the impression that you arouse my anger. You see, one can only be angry with those he respects," which sort of
That
had
was
the
a
White House
high-class diss,
press room.
unlike the
That was the
Yeah.
press. That was the press. That was the press conference. The first press conference Nixon held after the Saturday Night Massacre. Yeah.
And Vice President Ford, who everybody respected, actually said that the Watergate investigation is all a play towards the midterm elections, believe it or
Oh,
not,
wow.
which we're hearing now.
He changed his
many
mind.
years later.
He changed his.
We're going to open up to audience questions.
him
While
a
we
break.
do, Earl, you are just a guy trying to do his job in the Justice Department, and people were punching you about the head and face from both sides. What was that like?
It just was, that kind of case was one where you could satisfy nobody. And I remember going into Chief Judge Circus' chambers one time in the course of the grand jury proceeding and saying, I am getting, we had been chatting and talking about matters unrelated to the case, but he said, I'm getting beat up out there. And he said, well, just play it down the middle. I said, well, that's what I'm doing, and I'm still getting beat up out there. The Democrats were calling me a wuss. The Republicans said I was worse than Attila the Hun, and that I was acting like a DA. Of course, I was a DA. I mean, but that it was. It could satisfy no one, but you know, you do your job and do it the best that you can, and treat other people respectfully and reasonably. Most of the time, it'll turn out all right.
That's a good point to end on. Any Q&A? We've got a couple of folks with microphones if you have a question for the panel. No questions for the panel? I have a question, which is, if you were special counsel Robert Mueller or a member of his team right now, what would you be doing at this moment as the midterm elections approach and as the investigation appears to be winding down, but there's a threat that somebody might pull the plug on you?
Well, I'd be doing some of the things which it appears that he's doing, which is, to the extent that he can, handing off parts of the investigation to other elements within the Department of Justice. Yes, and in some cases to a state attorney general. Yes, with respect to the Southern District of New York, the president, I suppose, could fire those people too and shut down that investigation too, but it becomes harder and harder, you know, politically to do that. So, and one of the things that that phrase that was mentioned by John, by Judge Sirica, the law can take care of this situation. There's this assumption here in Washington, well, he's going to fire Rod Rosenstein, and when he fires Rod Rosenstein, if Sessions is still around, he's going to, his replacement, he's going to tell his replacement what to do. And there seems to be this and that replacement's going to fire Mueller. And there seems to be just this assumption that that's going to happen. But I think people in this town care about their reputations. And I think anybody who came in to replace Rod or to replace Sessions is going to say, wait a minute, let's talk about, like Jaworski did, let's talk about the ground rules, because I don't want to be pilloried for the rest of my life.
I'm sorry. In an answer to what Bob Mueller should do or would do, I have no inside information, but if he followed the model of Watergate, he could be, and maybe has already done, prepared what we called a roadmap with as much evidence supported by every document, every tax return, which I'm sure he has, and file it with the court. Because once it's with the court, it's out of the hands of the executive branch.
Don't forget the safety deposit box either.
All right,
Rob?
we've got a question.
So you've all mentioned Chief Judge Sirica several times. I believe he was named Time Magazine Man of the Year
He was.
during Watergate. And my question, two questions for you is, one, would Watergate have ended the same way if he hadn't been involved as much as he was, number one? And number two, did he have too many ex parte conferences with prosecutors? Because I get the sense there were a lot of them.
I won't answer. I'll let John and Earl answer the second question, but I think I don't know who the other judge would have been, but I think it's crucially important who your judge is. Sirica surprised a lot of people. He was known, wasn't he, as Maximum John? He had been a friend of Joe McCarthy. He was a very, very conservative judge, and I think I don't know if it would have been the same without somebody with his strength of character, just like the judge you had in the Ted Stevens cases, Emmett Sullivan. If we had Emmett Sullivans all over the country, we wouldn't have the kind of Brady violations that we have.
I strongly believe that it would have turned out differently if it were Chief Judge Hart who succeeded Judge Sirica, because of a number of rulings he made, a number of public statements he made, which showed he viewed his responsibility differently. Regarding ex-parte communications, I don't know of any inappropriate ones. There are appropriate ones that prosecutors have, but I'm not saying there weren't any. I just don't know of whether there were or not.
By the way, Earl, you had your moment where you went and talked to Judge Sirica. I had a moment where Judge Norma Holloway Johnson was running our grand jury.
Oh, dear.
And I came in one morning to discuss something with her, and there had been a story in the Post that morning that our investigation had gone on longer than World War II. And she mentioned that to me, and I said, Judge, that's only if you talk about American participation in World War II. If you're counting from the invasion of Poland, we're still okay.
And did the chief find that charming or not, Saul?
She did not.
Yeah, I would imagine so. We have another question.
Thank you. How would you compare today's media environment with the media environment from the Watergate era, and how does it affect you?
I mean, to me, you can't compare it because now we have a 24/7 news cycle where even though if you watch two of the channels, you see one view of the world, and another channel, not mentioning any names, but of course you see a totally different view. So then we had Woodward and Bernstein, who to us, that was fascinating. This was basically, although there were two, this was basically a one newspaper town. And every morning at breakfast, we would all read the Post. We'd read what they were writing. Sometimes they got it right, sometimes they got it wrong. But we just found it interesting, but we weren't, then when we got to work, we didn't really care that much about it. And believe it or not, I don't think their source was called Deep Throat then. I'm not sure they named the source deep, quote-unquote, Deep Throat. But we really didn't care. We frankly didn't give a darn who was giving them the information. And but it was Woodward and Bernstein. That was the effect of the media then. The internet either. No, I'm saying there was of course, no internet. Yeah.
Earl, what about the media? You've lived here a long time, seen a lot.
Well, a couple of things. One, the U.S. Attorney's Office did not have any public information officer or anything like that. And as a consequence, I guess I was supposed to handle it as the person in charge of the investigation, but I never dealt with the press, which the press didn't appreciate. And there are a number of reasons why, but the principal Reason why was you can't, as a prosecutor, discuss evidence that, or what's going on before the grand jury or FBI interviews. That's off base. You just can't get into that. It's unethical to do so. It's unfair to the persons under investigation. You don't do it. And my approach and practice was not to talk at all. Now, and no comment was the mildest comment. I just wouldn't do that. But, in a way, with the benefit of hindsight, it might have been a mistake on my part for not trying to address the problem, because by not saying anything and being at that time in a Nixon Republican administration, by not disclosing, there were people that drew the inference that they're trying to hide something, trying to conceal something. Not at all trying to comply with the ethical rules that govern the conduct of prosecutors. But in terms of, when Doyle, who Saul has mentioned in his book, went over to the special prosecutor, or the independent, special prosecutor, Archibald Cox, Cox's first hire, as I recall, was Doyle, who was a PR person. And there are certain advice that can be given. For example, in the Watergate investigation, that was largely what I call the Washington Post work. You may disagree with this. Was largely a leaks investigation. We in the U.S. Attorney's Office and the Department of Justice, and this isn't well known, we were always ahead of the Washington Post in the investigation. Now, I read the Post and all the New York Times, Evening Star. I read them every day because I wanted to see if the press had something that we didn't know about. But the fact of the matter is, we were always as ahead of them. But the Post was very good, and some Sandy Smith from New York, from Time Magazine, and some others were very adept at getting to the leaked information. And, the leaks went. We conducted the investigation. We came across whatever it was. Then someone leaked it, and we suffered from leaks throughout the investigation. And the press was very good in picking up the leaks, not from us, but they picked them up. I think the benefit to the government from the activity of the Washington Post and others was not, as I said, for the facts they uncovered, because we uncovered the facts, and as I said, we're ahead of them. But they kept up interest in this case, kind of a drumbeat of information, accounts, stories in the news media, and that wouldn't let and in a way, that kind of stopped the government of us from being shut down. We were 3 assistant U.S. attorneys. I mean, we weren't assistant attorney generals or U.S. attorneys. We were 3 assistant U.S. attorneys conducting an investigation. And if it weren't for the news media keeping, stories going and keeping interest, I think speculation on my part that there might have been an effort to shut us down, which never happened. We were left alone. That is, the 3 of us together with the FBI, and that's why we were able to conduct the investigation that we did.
Saul, a quick question to you. Some new information has emerged, maybe not new to you, in the course of the Kavanaugh nomination process that suggests that Ken Starr was authorizing people in his office to talk to reporters.
Well, we didn't make any secret of the fact that some of us were authorized to talk to reporters. Thank God it wasn't me. We had a press officer. We always had a press officer. Ultimately, we got Chuck Backley, and it's a dangerous job. He ended up being indicted for grand jury leaks, and fortunately tried by Norma Holloway Johnson, and fortunately acquitted of that. But we were accused of something much more serious than that. We were accused of 6E violations, certain people in our office, again, primarily Backley, and that investigation by a special master cleared us. So the fact that somebody is authorized to talk to the media, I mean, Doyle That was one of his major jobs, was to have background talks. Archie Cox, I learned from this book, had background talks with members of the media. There's often not an appreciation of the difference between the two. However, Doyle talks about something really interesting, which is a trap sometimes that press people fall into when you're doing an investigation like this. A reporter will say to you, here, you don't have to tell me anything, but I'm going to tell you what I've heard. And I want you to tell me if I'm on the wrong track or not. Well, if the reporter then says to you, all you have to do is tell me if I'm wrong or just completely off base. Well, if a reporter says something to you that basically you only know because it's grand jury information, that could be interpreted as leaking grand jury information. So it's a dangerous job, as Chuck found out.
Any more questions? I think we have time for one or two more. Yeah.
Question for Earl. Were you debriefing the rest of your team on the Peterson meetings?
On what?
The Peterson.
Oh, was I?
The question was, were you debriefing your team?
Were you debriefing your team
meetings
on your
with
Peterson meetings?
Yes, of course. Of course, I was doing that.
And how were they
I think that's
reacting?
why I wouldn't do that. I didn't have secrets with the three of us. Were like one, basically. I mean, I was the person technically in charge. I had the title, whatever that is, but we were three together working. And
Well, and Peterson's head of the criminal division, so it's perfectly natural for you to brief Peterson, right?
Oh, of course. I mean, he falls within the statute as to those who are entitled to receive information. What's going on, and as the head of the section, I just can't think of why you wouldn't do that. I've never heard of assistant U.S. attorneys who are working on a case, when reporting to their supervisor, and they can't tell the supervisor about what's in the grand jury. That's news to me.
But you said earlier, in something that really got my reporter antenna going, that at least on one occasion you didn't share certain transcripts with Mr. Peterson. Do you remember which ones those were?
No. What, now?
Yeah. It was a long time ago. It must have been pretty hot, though.
Well, it was if you want to use the word hot.
Reporter's privilege.
During the period of from April and May and in the first part of June, there was no let-up in terms of the speed or the expedition in which the investigation was going on. It was one right after the other, into the grand jury and then on to the next. A lot of things were happening, but the necessity for certainly conveying information to your chief, you do it. We had some differences, Henry and I, during the course of that investigation, and it's not easy, and it was difficult. But you have to iron them out one way or the other in the best interest of your client, which is the United States.
And people, and just in terms of dates, people forget, I don't think we've said this yet, but what really broke the case wide open was Jim McCord's letter delivered to Judge Sirica on March 23rd, 73. Archie Cox isn't even confirmed until May 22nd and doesn't set up shop fully and get up and running. Well, Earl, you were there, I think you told me, in a transitional period till the end of June. And it's during that period that Magruder and Dean first come in and start spilling the beans. And some other people, too. I think either LaRue or Mardian. I don't remember which.
They all came in. Yeah, I'm trying to, if I'm sitting here trying to think of someone that, other than the President of the United States, his chief of staff, his economic counselor, John Dean, many times, Magruder. We were talking to them all and trying to develop a case, as the result of which, when Cox came on, I handed him a 85 to 90 page status with respect to where we were and how far we had come, which was a long way.
One last question for you. in the current investigation that we're all living through right now, a lot of people seem to be winding up facing charges and pleading guilty to lying to the investigators. How new is that, if at all? Did you have a lot of lying, an epidemic of lying in Watergate and Whitewater? And if so, did you charge that, or did you charge the underlying violation?
Actually, very interesting. One, that is, the three of us encountered lying. In that memo that I wrote to Cox, I laid out 19 people who either committed perjury or misleading testimony, who had relevant material that didn't come forward. So, but you correct me, John, on this. I had resigned, so at the time the major indictments were coming down of Haldeman, Ehrlichman, John Mitchell, and the like by the special counsel and the prosecutor. Very interesting to me, the indictments did not include charges of the burglary that led to the investigation in the first place. All the counts of the indictment, including the conspiracy account, were for obstruction of justice, lying, perjury, or the like. Now, I think there were technical legal reasons for putting it that way. I never discussed this with John or some others in the independent counsel's office, but that kind of struck me when I saw that indictment. You say, well, because we were going after both. I wanted to indict people, those who we thought deserved it, for both the substantive offense, the underlying burglary and the like, and the obstruction of justice. And here was Professor Cox and Jim Neal with their outstanding staff that chose to go, as I read the indictments, only with the obstruction of justice type related offenses.
They had so much to work with.
I mean, our staff was incredible. The youngest lawyers on the staff were 7 people who had just left the Supreme Court clerkships. And there were technical or legal defects that were carefully studied in charging that way. But just very quickly, regarding the people now who are all pleading guilty to 2001 to lying violations, it's a prosecutorial judgment. The strategy is we're using these people as witnesses in what we may make as the big case, and we're going to put the lies behind them. Everyone who comes in begins with lying. And if they've lied to the world, they're going to lie in their initial meetings with prosecutors. And what we want them to say, if we're the prosecutor, when they testify, we want to bring out on direct examination. Initially, you lied. Here it is. You're admitting it. You pled guilty to it. Now you're telling the truth. It's to take the sting out of cross-examination. Whether or not that's the best way to do it is debatable, but that's the thinking.
I think an important thing that gets overlooked is whether you call them a special counsel or an independent counsel. Everybody in town knows, everyone in this town knows, they're going to have a limited period of time to do their job before they start getting attacked. So I think it's very important. I think the last person left in the world that still believes in special counsels and independent counsels precisely because of your, if it's done right, your freedom from coercion. But I think it's very important to strike fear in the hearts of people you're investigating if you're going to do your job from the beginning. That's what Patrick Fitzgerald did in the Scooter Libby, what became known as the Plame, investigation. And he wasn't very popular in this town. He went after reporters for reporters' privilege, and he went after anybody who lied. And in the case of Mueller, in addition to doing that, he came and did the morning raid on Paul Manafort when his wife was in her robe or nightgown, which no other prosecutor in the world, of course, has ever done, right? And but it sent a signal to people, and Fitzgerald sent a signal: I'm not screwing around. And I think one of the big mistakes that Judge Starr made early on, that he usually isn't criticized for this, that I think a mistake he made. He didn't have a criminal law background. He was friends with all these people. These people are my friends, and we're all gentlemen. And he had a completely different approach, and I think he got rolled. And after a few years, he realized he had been rolled, and he put people with more prosecutorial background in positions of authority. All of this happened before I got there. I got there fairly late. But when he finally started getting tough, people in this town were enraged because some of it was substantive, but I'm talking about even on the original core allegations, because, wait a second, you haven't been treating us that way from the beginning, and now you're trying to be a tough guy. We've been rolling you for 2 or 3 years. You never have that issue. Whatever else they feel about Mueller and Fitzgerald, people are scared to death of them. And I just think that's what a special counsel has to do. That's part of the game.
A special
right.
counsel or an independent counsel has to be independent by definition, but has to be accountable. And if they're not accountable, then it's very dangerous.
We're going to end it there. Thank you so much. Please give a warm round of applause to this all-star panel.
Thank you. Did I say Stonewall again? Stonewall.
There you go.
And
I
the
didn't
bar
know there
is
was a
open
secret word
outside.
for CLEs, but there is.
It's time for cocktails on the veranda.
Plugging
or
Ben
whatever
Benesti's
that
book. I think that's the name of it.
Yeah, there's a book called Stonewall, too, one of the Watergate books.
Yeah, who wrote that? I'm trying to think.
Ben
Ben
Bernstein.
Benesti.
Oh, yeah, and Frank.
And George
Ben
Frampton, yeah.
Bernstein.
Thank you.